Hi there, welcome to Help Solve the Case. I'm Christine, retired police detective and sergeant, current law enforcement expert, and forensic genetic genealogist. We've all been watching the Tyler Robinson, Charlie Kirk preliminary hearing, which is not over, but we did get a significant amount of information. As you know, if you've been following me, thank you, thank you. I tried my best to scribble my way through it and probably was not able to capture all the information. So, as promised, I compiled everything into a report, yes, using my AI assistant and the actual transcripts from the court hearing. And we're going to take a look at that today. So, while I share that, I wanted to let you know that I really, really, really appreciate you guys being here. Hopefully, wish I could move that a little further. Uh, I really appreciate being here. I don't know how that's going to go. We'll try doing it this way and see how that works. All right, so we're going to go through this document. I perused it a little bit. AI helped me write it using the transcript. Again, I've got a disclaimer here. We're just going to see what it's going to tell us, how it positions it. It may agree with your theory, it may not, but let's just see what it says, okay? Because I think it's a general response from what was presented. And I think many times it helps to look at a different perspective or theory than our own. Okay, so I've got a disclaimer here. Like I said, innocent until proven guilty, made with AI, not a formal legal opinion. Let's just see what this says. All right. So this report is organized by evidence topic rather than by hearing day. Makes it easier to see how the state built its case. Remember, because this was the state's job to put on the preliminary hearing, where the defense challenged it, and which questions remain open. Now, this hearing is still open. All right. So, um, here's just some like the label established for this hearing: testimony or an admitted exhibit directly supported the point, supported by inference. The point depends on connecting separate facts or interpreting an image, statement, or circumstance. Challenged: the defense identified a factual, scientific, evidentiary, or legal limitation. And not yet resolved: the hearing record discussed the issue but did not conclusively answer it. Okay, now these are like, we have our own table, I guess, like we have the DNA qualifications table. Okay, so the AI gave us our own table of wording here, like we talk about semantics. Okay, so across 5 hearing days, the prosecution presented a layered case built from surveillance, witness testimony, digital communications, the recovery of a rifle, DNA testing, and Robinson's surrender. The defense did not rely on one single alternative theory, which is true, right? We didn't hear them going in one direction. They were just asking questions. Instead, it attacked the reliability, admissibility, interpretation, and public presentation of the state's evidence, right? We saw that. We saw that with the reliability of the witnesses, how they came to their conclusion, the admissibility, the hearsay, the 1102s, the semantics about the interpretation, and the public presentation, right? The media, the public being able to see it. So, it says here the state's case is strongest when the evidence is viewed cumulatively, okay, all together. Surveillance provides movement and timing. The communications provide alleged admissions and explanations. The rifle and DNA provide physical corroboration. Each category has limitations, but together they form a coherent, probable cause narrative. Now, this is the AI viewing this as a spectator, okay, just like we did. The state's core theory: Robinson visited and moved through the UVU campus before the shooting. Remember Chick-fil-A, the car being seen, okay, this is according to the state. He returned in different clothing, crossed onto the Losi building roof, and moved into a prone position overlooking the event. A single rifle shot was fired at approximately 12:23 p.m. The rooftop individual immediately fled. jumped from the building, crossed Campus Drive, and entered a wooded area. Police recovered a bolt-action .30-06 rifle wrapped in a towel in the area associated with the escape. And I'm just wondering if I can, let me zoom this a little. Maybe that might help you guys a little bit. Okay. Hopefully that's better. I haven't tried this layout. We'll see. Messages attributed to Robinson described planning the shooting, hiding the rifle, changing clothes, attempting to retrieve the rifle, worrying about prints, and deciding to surrender. DNA testing produced support, again, this is the state's part, produced support for Robinson's inclusion on multiple areas of the rifle, cartridges, and other items. The defense's core challenges. The rooftop video does not independently show a clear face or an unmistakable firearm. Investigators initially detained and evaluated other people and other weapons. Some testimony relied on hearsay permitted at a Utah preliminary hearing under Rule 1102. The defense challenged authentication, edited or enhanced video, prosecutor-led witness statements, and the public broadcast of alleged omissions. The defense used the ATF's own DNA analyst to establish that DNA cannot prove when, how, or through what activity DNA was deposited. Complex mixtures, transfer, shared household contact, and scientific reporting limits reduce what the DNA can prove by itself. So here's the bottom line. The prosecution appears to have presented substantial evidence supporting probable cause on the central homicide and firearm counts. Remember the first one, that there was a homicide, and then that it was a gun, right? A weapon. The alleged text admissions are the most consequential evidence because they connect identity, planning, motive, the rifle, concealment, and surrender in Robinson's own attributed words. The defense's strongest work was not disproving the state's narrative. It was showing that several important parts of that narrative, especially surveillance, identification, and DNA, must not be overstated, okay? So again, we're unbiased here, right? We're looking at it from all sides. So if you're on the prosecution side, you're like, I think we did a good job, right? The AI is saying you did a good job. If you're on the defense side, they're saying, well, hey, all is not lost. You showed that several important parts of the narrative, the surveillance, identification, and DNA, can't be overstated, right? So we talked about what the state needed to support in the preliminary hearing. So we had count one was the aggravated murder, the intentional or knowing killing while creating a great risk of death to another person. So people talked about being shot through a crowded event, eyewitness testimony, trajectory and crowd evidence, surveillance, alleged omissions, rifle, and DNA. Okay, so this is what the AI is saying is, our we'll say hopefully unbiased. I didn't tell it to take any side or whatever. This is our unbiased observer, right? And if you're on the defense, you hire jury consultants and all that, right? You hire people to have a different perspective than yours so that you can anticipate what regular folks will say. The same thing goes for the prosecution. So with our DNA here, our AI here, I thought it would give us a unique perspective to just say, what is it coming up with? What did it take away? Because I know some of you are on one side, some of you are on the other, some of you are undecided, okay? And this is what it's saying. Count two, the felony discharge causing serious bodily injury. Discharged a firearm, here's the allegation, discharged a firearm towards Kirk while knowing or having reason to believe he could be endangered. Serious bodily injury resulted. Single rifle shot, immediately collapsed, medical evidence, rooftop line of sight, surveillance, recovered rifle, right? The medical evidence, I believe, is what they were referring to in the medical examiner's report. Now, we did not see the medical examiner. Okay. Now, here's obstruction. Concealed or removed the firearm to hinder the investigation. The rifle was recovered in a wooded area. Text about a drop point. hiding it in a bush, attempted retrieval, and concern about prints. Here's another obstruction charge: clothing. Destroyed, concealed, or removed clothing worn during the shooting. Surveillance showed changed clothing, alleged statements that clothing was disposed of, searches, and witnesses' account. Witness tampering, delete messages. Attempted to cause the roommate to withhold information or an item by deleting incriminating text. Message attributed to Robinson, delete this exchange. Witness tampering, stay silent. Attempted to cause the roommate to withhold testimony or information. Message attributed to Robinson advising the roommate to ask for a lawyer and stay silent if questioned. Violent offense in the presence of a child. Committed criminal homicide in the physical presence of a child under 14, knowing a child was present and might see or hear it. Crowd and event footage, testimony and exhibits showing children near the event. Okay. It says the filed information also alleges a victim targeting enhancement based on the claim that Kirk was intentionally selected because of Robinson's belief or perception regarding Kirk's political expression. So, I don't know. I don't see that we have supported that in here, and I don't see where the AI is talking about that. 1. The shooting scene and rooftop, what the state presented. Officer Christopher Bagley described the UVU courtyard, surrounding buildings, low-C rooftop, access points, and the sightline towards Kirk's event. Bagley heard a single gunshot at approximately 12:23 p.m. and saw Kirk move or collapse immediately. Based on his firearms experience, Bagley believed the sound was more consistent with a rifle than a handgun. He ran to the low-C roof and observed a red and black screwdriver and a potential shooting area, what they're calling the perch, right? The state used photographs and aerial images to establish the physical relationship between the roof, courtyard, parking structures, and escape routes. The defense challenges. Bagley did not see the shooter fire and did not witness the later arrest or identification. His rifle versus handgun opinion was based on one sound in a chaotic environment. The defense repeatedly challenged the authentication of photographs because Bagley did not take them and could not identify the photographer or exact creation date. The Sorensen building partially obstructed portions of the sightline, making the precise shooting position important. So here's the assessment. The testimony strongly established the scene. Again, this is not me, this is the AI. Let's see what it says. The testimony strongly established the scene, the sound of a shot, the timing, and the feasibility of a shot from the low-C rooftop. It did not identify Robinson. Its value is foundational. It allowed later surveillance, trajectory, and physical evidence testimony to make sense. Surveillance and movement timeline, what the state presented. Agent David Hull described investigators working backward and forward from video of an individual on the roof at the time of the shooting. The state presented surveillance, it said, showed Robinson arriving around 8:30 a.m., walking through campus, leaving, returning with a blue backpack, visiting Chick-fil-A, moving into a wooded area, and later appearing without the backpack. A later return showed an individual in different clothing and walking with an unusual gait or limp. The individual crossed the railing onto the low-C roof, ran towards the southwest corner, crouched or crawled into position, remained there until the reported shot, and then fled. The individual jumped from the roof, crossed Campus Drive, entered the wooded area, and later returned in a vehicle associated with Robinson. Defense challenges. The rooftop footage alone did not show a clear face. Agent Hull acknowledged he could not literally see a gun in the person's hand. He saw an object that could be consistent with the firearm. Drivers who passed the fleeing person did not report seeing a man openly carrying a gun. The state's identification depended on linking multiple cameras, clothing, gait, vehicle records, and later information, not one definitive image. The defense noted that additional video angles existed, but were not shown at the hearing. Here's the assessment. The surveillance is powerful as a sequence, not a single image. It creates a continuous circumstantial timeline. Its principal vulnerability is identity. The state must demonstrate that the same person appears across the different clips and that the person is Robinson. Right? Connect the dots. The rifle, ammunition, and physical recovery, what the state presented. Investigators followed the suspected escape route into a wooded area and recovered a bolt-action .30-06 rifle wrapped in a towel. The rifle contained a fire cartridge case and unfired cartridges with etched inscriptions. The state emphasized that no casing was found on the rooftop, which is consistent with a bolt-action rifle retaining or requiring manual extraction rather than automatically ejecting a casing at the firing position. Messages attributed to Robinson referred to a grandfather's rifle, its serial number, a towel, a bush or drop point, engraved bullets, fear of fingerprints, and attempts to retrieve it. A separate live .223 cartridge found on the computer science building roof was described as unrelated to the direct shooting position because that roof lacked the relevant line of sight. Defense challenges. No witness testified to seeing Robinson carry or fire the recovered rifle. The state's interpretation of the object in the surveillance video remained inferential, means making an inference. The defense explored other firearms recovered or reported at the event and the early confusion over the first person detained. The rifle's ownership history and modifications require careful chain of custody and provenance analysis. As an ATF, they can do all kinds of things with the guns and everything. Assessment. But remember, I think it was the ATF person that didn't know that the gun came from Germany. Was that the ATF person? Here's the assessment. The rifle becomes substantially more important when paired with the messages. Without the communications, its connection to Robinson would depend more heavily on surveillance, DNA, ownership, and recovery location. With the messages, the state has an alleged explanation for why it was hidden, where it was left, and why Robinson wanted to retrieve it. The text messages, note, and Discord communications. Why this was the turning point. Day 4 changed the character of the hearing, according to the AI. The state moved from proving a circumstantial timeline to presenting communications attributed to Robinson that appeared to explain the planning, shooting, rifle, concealment, and surrender. Key statements attributed to Robinson. A direction to look under a keyboard where the roommate said he found a handwritten note. An admission in response to whether he was the person who committed the shooting. A statement that he had planned it for, quote, a bit over a week, end quote. A statement that he had, quote, enough of Kirk's hatred, end quote, and that some hate could not be negotiated out. Statement about retrieving the rifle from a drop point, a squad car near it, a bush, changing outfits, fingerprints, a towel, and the rifle's serial number. Reference to engraving bullets. A direction to delete the message or the text exchange. A later statement that he would turn himself in. Advice to the roommate to ask for a lawyer and stay silent if questioned by the police. Authentication presented by the state. The roommate identified the phone, the contact, the conversation, and the attributed participants. Agents photographed the phone during the first interview. A Cellbrite extraction was performed on the roommate's phone. The attributed phone number was checked against law enforcement records. The roommate identified the handwritten note and said he photographed it where he found it. The roommate identified the Discord group and Robinson's alleged account name. Defense challenges. The defense challenged the use of the roommate's recorded Rule 1102 statement rather than live testimony. It argued that portions of the recorded interview consisted of leading prosecutor narration. hearsay, best evidence problems, irrelevant information, and unfair prejudice. The defense also argued that broadcasting the alleged admissions could prejudice the future jury pool. Use immunity, the passage of time between interviews, and the context of the roommate's relationship with Robinson remain relevant to credibility and trial strategy. So here's the assessment. If authenticated and admitted at trial, the communications are the state's strongest evidence. They do not merely place Robinson near the scene, they allegedly supply identity, intent, planning, motive, concealment, knowledge of details, and consciousness of guilt. Notice it's not the DNA here, right? They're not talking about the DNA here. They're saying that this digital evidence, and if they extracted the phone, we haven't seen any like digital location detail or anything like that. So we don't even know what that's going to say. Surrender, arrest, and searches. What the state presented. Agent Brian Davis testified that investigators learned on the evening of September 11th that an individual intended to surrender in southern Utah. Robinson arrived at the Washington County Sheriff's Office with his parents and a family friend. He was formally arrested in the early morning of September 12th and transported to the Utah County Jail. His phone had been seized, and later warrants authorized collection of clothing, buccal swabs, fingerprints, and palm prints. Search warrants were executed at Robinson's residence and his parents' residence. A family friend was described as helping facilitate the surrender. Defense perspective. Voluntary surrender is not itself proof of the charged conduct. The defense can distinguish surrender from flight and may argue that later cooperation affects how consciousness of guilt evidence should be interpreted. Remember, they were talking about he turned himself in, he did everything. Remember that? I think it was the female defense attorney was talking about that. Agent Davis was not personally present for every search or evidence recovery step and sometimes relied on reports from other officers. Assessment. The surrender evidence establishes custody and investigative chronology. Its strongest evidentiary value comes from how it corroborates the communications and family accounts, not from the act of surrender standing alone. DNA evidence. What the state presented. ATF forensic biologist Caitlin Oliver authored the DNA reports. Testing produced support for Robinson's inclusion on multiple areas of the rifle, including the stock or grips, butt plate, trigger and trigger guard, bolt, fore-end, barrel, optical accessory, protected underside of the receiver, a fired cartridge case, cartridges, and other associated items. For some samples, the likelihood ratio reached the laboratory's reporting cap of at least 1 trillion. The laboratory was accredited, the methods were validated, and Oliver met required competency and proficiency standards. What the defense established through the same witness. The analyst does not make an absolute source attribution. A likelihood ratio does not state the probability that Robinson committed the crime or even the probability that he is the source. DNA cannot determine when it was deposited. DNA cannot determine how it was deposited. And DNA cannot determine what activity caused the deposition. Secondary transfer is possible. A person may contribute DNA to an item the person never directly touched. Shared household items can contain DNA from multiple residents or visitors. Many of the evidence profiles were mixtures, including complex mixtures with 4 or 5 contributors. As contributor numbers increase, interpretation becomes more difficult. Some samples were consumed during testing, while extracts remained for others. So here's the assessment. The DNA strongly associates Robinson with the rifle and related items, but it does not by itself prove that he fired the shot at UVU. Its force depends on context. DNA on a family or household firearm may be expected. DNA on protected internal areas, a fired cartridge case, or items matching the escape narrative may be more probative. The exact weight requires an item-by-item analysis. 7. The investigation and alternative leads. Points developed on cross-examination. The person first taken into custody was not ultimately considered the shooter. Several people were detained or interviewed and later cleared. At least one handgun was found in another person's backpack. A trooper's report raised an issue about whether a gun was associated with the holster found in the crowd area. No bullet or casing was reportedly recovered from the Losi rooftop area itself. Investigators had substantial amounts of video, and only selected compilations were used at the hearing. The identity of the rooftop person was developed through an investigative chain rather than immediate facial recognition. Assessment. These facts show an initially chaotic mass casualty scene with multiple armed people, early detentions, and competing leads. They do not necessarily undermine the eventual identification, but they are important when evaluating tunnel vision, confirmation bias, and whether later evidence was interpreted after investigators already knew Robinson's name. 8. The major legal and evidentiary fights. Photograph authentication. The defense position is that it's an unknown photographer and date. The witness did not create the image. The state says a witness familiar with the scene could authenticate a fair and accurate depiction, and the objections were overruled. The Rule 1102 hearsay. The defense position was the use of recorded reliable hearsay violated constitutional protections and deprived the defense of live confrontation. And the state said the court had previously upheld the use of reliable hearsay at the preliminary hearing, and the standing objection was preserved. Enhanced video. The defense said that it edited highlighting zooms and public display risked prejudice. The state said enhanced version admitted, the state position ruling the enhanced version was admitted. The judge limited or controlled publication where cumulative. Recorded roommate interview. The defense said it was leading prosecutor narration, hearsay, best evidence, Rule 403, privacy, and fair trial concerns. The court reviewed the redactions and permitted a redacted version while separately admitting communications. The public broadcast of admissions. The defense said televising alleged confessions could poison the jury pool. The state's position or the ruling, the court distinguished voluntary private communications from a televised custodial interrogation and relied on voir dire and trial management. The media order violation. An exhibit prohibited from broadcast appeared briefly on the live stream. Defense sought exclusion of the cameras. The court found that a violation was there, but imposed a narrower sanction. No further exhibit capture during the remaining hearing day. Okay, we've got the scope of defense DNA testimony, and the defense position was that scientific limitations affected reliability and weight. The state argued the defense was turning the hearing into a trial or Rule 702 hearing. The court limited some questioning, but allowed core limitations. So now we get to the evidence, the strengths and vulnerabilities. Again, what our independent AI observer says. So the text and the notes, it helps the state because they are alleged direct admissions. They show planning, motive, rifle details, concealment, and surrender. But the principal vulnerability is authentication, completeness, context, witness credibility, and admissibility at trial. The surveillance helps the state because it tracks a person through campus, roof access, shooting window, and escape. It's vulnerable because there's no single clear facial identification that we know of. The object in the hand is interpreted, and it's not visibly confirmed as a rifle. The rifle recovery helps the state because it was found along the escape route. It's a physical match to alleged messages and the edged cartridges. But no eyewitness saw Robinson fire it. There are ownership and handling history that matters. DNA. Support for Robinson's inclusion across multiple rifle components and ammunition-related items. The vulnerability. You can't prove timing, activity, last handler, or guilt. Mixtures and transfer complicate the meaning. Surrender, right? Robinson's surrender helps the state because it corroborates the timeline and attributed messages. It gives investigators custody and access to evidence. But voluntary surrender is not an admission by itself. Roommate testimony can authenticate communication and describe conduct after the shooting. But recorded statements, leading questions, use immunity, relationship dynamics, and credibility issues can make it vulnerable. Scene testimony establishes the shot, crowd, line of sight, rooftop access, and physical feasibility, but it doesn't identify the shooter. So now we have the count-by-count preliminary assessment, right? Because we have to meet all the charges, the elements of the charges that he was arrested with, okay? The probable cause. So the aggravated murder. Strong probable cause support from death, single shot, surveillance rifle messages, and DNA. Risk to others theory supported by the crowded setting and shot path. The unresolved issue is trial admissibility and credibility of the communications, precise trajectory, and risk evidence. So we don't know if these are going to be, if they're unresolved, if they're going to affect the preliminary hearing, or we're talking about potential trial, okay? Felony discharge. Strong support that a firearm was discharged toward Kirk and caused fatal injury. Identity of the shooter remains a cumulative inference rather than a single direct inference or observation. The rifle with the obstruction charge. There's strong support if the texts are credited. Hiding the rifle, the drop point, attempts to retrieve it, and concern about prints. The unresolved issue is the authentication and whether the recovered rifle is conclusively the firearm used. The clothing obstruction charge. There's moderate to strong support from clothing changes, alleged disposal statements, and surveillance. But what clothing was recovered, where it was found, and for forensic linkage, we haven't heard about that. Tampering, deleting the text, directly supported by the attributed instruction to delete the exchange. Legal interpretation of intent and authentication of the conversation is still unresolved. The tampering with the stay silent is again supported by the attributed instruction to seek counsel and stay silent. The unresolved issue, whether constitutionally protected legal advice in context satisfies criminal intent to induce withholding. That's interesting, isn't it? Presence of a child, supported by event footage and testimony that children were present near the shooting. Vulnerability, proof of Robinson's knowledge that a child was present and might see or hear the homicide. And the victim targeting enhancement says supported by alleged statements about Kirk's hatred, political discussions, and event-related evidence. Vulnerability, whether the evidence proves intentional selection because of political expression rather than a broader personal or ideological motive. Okay, so we got some questions here. What the hearing did not fully answer. What is the final complete ballistic comparison between the recovered rifle, fired cartridge case, projectile fragments, and Kirk's wound? Was usable fingerprint or ridge detail evidence recovered from the rifle, cartridges, screwdriver, note, towel, or other items? What phone location, vehicle location, or network evidence independently corroborates the surveillance timeline? Because you have to think about, from the prosecution perspective, if the defense successfully removes an item of evidence, can they still support the case? Okay, so they need to, it's like a three-legged table. right? Can a table stand on only two legs, right? So if something gets removed, can the case still stand up on its own? What was recovered from the clothing allegedly discarded, and what forensic testing was performed? How complete are the digital extractions of Robinson's phone, the roommate's phone, Discord, and other accounts? Are the text and Discord records supported by provider records, metadata, or device-level artifacts beyond screenshots? What evidence establishes Robinson's knowledge that children under 14 were physically present? What evidence distinguishes political targeting from a generalized dispute over speech, identity, or personal beliefs? Were all alternative suspects in firearms documented and eliminated through objective criteria? Which portions of Rule 1102 evidence will survive ordinary trial rules if the case proceeds to trial? The clearest audience takeaways. The hearing was not a trial, and the judge was not deciding guilt. The state did not rely on DNA alone. Its case combined surveillance, communications, physical evidence, witness accounts, and surrender. The text and note attributed to Robinson are the most damaging evidence because they appear to explain details that match the physical investigation. The surveillance is persuasive as a sequence, but does not provide a single clear facial identification on the roof. The DNA evidence is statistically strong as an association, but the defense correctly established that the DNA cannot prove how, when, how, or why it was deposited. The defense's best arguments are likely more powerful at trial, where the state must prove guilt beyond a reasonable doubt, and ordinary evidence rules apply more strictly. More arguing, right? At the probable cause stage, the cumulative evidence strongly favors binding the central charges over for trial, assuming the court credits the omitted evidence. And I told you guys that I thought that. Okay. Conclusion. The 5-day hearing revealed a prosecution case with a strong cumulative structure. The scene testimony established feasibility, meaning it's feasible. Surveillance supplied a timeline. The recovered rifle and ammunition supplied physical evidence. The communications supplied alleged admissions and an explanation for concealment. DNA supplied corroborating association. The surrender completed the chronology. Connect the dots. The defense, nevertheless, identified significant limits that should remain central to future coverage. The rooftop image is not a facial identification. An object in a hand is not visibly confirmed as a rifle. DNA is not activity level proof. Recorded Rule 1102 statements are not equivalent to live trial testimony, meaning a piece of paper can't be impeached, but a witness can. And the public filing or broadcast of an allegation does not make it reliable. The fairest summary is this: the state presented enough interconnected evidence to create a strong probable cause case, but several of the most important pieces will require stricter authentication, admissibility, and credibility testing before a jury could properly rely on them at trial. Okay. So what do you think? There we go. Hopefully that helped. I don't know. We've got a little chronology there. We've got some pros and cons, and we don't know what's going to happen on September 1st. We're going to have to, I feel he's going to be bound over, and then, maybe we're going to see more evidence in pleadings. We're going to see some constitutional challenges, maybe more evidence testing, motions to suppress, and things of that nature. There's probably evidence and different items that we don't know about. Okay. I don't think we saw the key witnesses. They're going to be hiring experts, jury consultants, all kinds of stuff. So there is a lot, we are just, we haven't even passed go at this point. Okay. He's got to be bound over, and then they're going to start running with it. And the defense seems prepared to fight in this case, as well as the state. So, like I said, we didn't see what I think is going to be the most important stuff. So I don't know if that helps. Let me know. Do you think the AI missed anything? Do you think it was an independent observer? I didn't tell it anything. I just gave it the transcripts and I said, create a report for me. And what would you like to see? What are you hoping to see? I know that a lot of you have been following more of this case, more of the details than I have, maybe looking at some of the pleadings, but just wanted to give you the play-by-play of the preliminary hearing. We'll have to wait for September 1st. And again, thank you for being here. I really appreciate your liking, subscribing, and sharing. All of this is to help inform you, help inform me about the court processes, and most important, to help forward the forensic genetic genealogy work so that we get good outcomes in these cases. So I will see you on the next one.